Well, good morning and welcome to today's presentation or mini seminar on 3 things you must know about the buyer's right to legally get out of the deal. I'm Jim Urquhart. Before we get started, you should know a couple things about this presentation where it's relevant. Let me cover those now. This presentation is relevant for the state of California, USA. Some of the principles will have application, of course, outside of the state of California, but it is specifically designed for use within the state of California, USA. In particular, we're going to be talking about some legal principles with respect to residential real estate, 1 to 4 units. That is the typical home or condo. Of course, your typical home is 1 unit, not 4, and your typical condo is 1 unit, not 4. That will be what the subject matter relates to today. This is being recorded on June 17, 2014. Next, since you're going to be listening to me for the next few minutes, let me just tell you briefly about myself. Again, I am Jim Urquhart. I am a realtor, which means I'm a member of the National Association of Realtors, the California Association of Realtors, and the local Realty Board. I am a licensed real estate broker, and I'm a licensed California attorney at law. I first became licensed as a broker in 1978. My specialty is residential real estate in the Coachella Valley, California, USA. And I'm proudly affiliated with Tarbell Realtors, who is our broker. I'm also a California attorney at law. I've been licensed in California since 1977. Hard to believe, but yes, it's been that long. My specialty in the law is tax audit defense, tax litigation, and tax trials. And yes, I am a full-time real estate broker, and I am a full-time attorney at law. I do both. You should know a little bit with respect to the broker versus attorney at law. In real estate transactions, if I'm representing you in a real estate transaction as a broker, I will only be acting as your broker, not as your attorney at law. So I can't be your agent and your attorney at the same time. I'll only be acting as your agent. But the lawyer part of my brain does not turn off. That knowledge is still there and available to assist with the transaction. Let me set the stage of what we're going to be talking about for the next few minutes. Let's assume we have a seller that has accepted a $500,000 offer to buy his or her home. All the offer and acceptance paperwork has been duly signed and delivered, so that means the property is now under contract to be sold. I'm going to be referring to that as the deal. A deal has been made. It's under contract. A deal has been made. The transaction has progressed to the point where the buyer, in good faith, has put down his 3% earnest money deposit, and for a $500,000 deal, 3% of course is $15,000. Just a quick note on that: the deposit by the buyer can be more than 3%, can be less than 3%, but it is quite standard here in the Coachella Valley and in most parts of California that there's a 3% down with respect to residential real estate. That can vary. The seller can demand more or less. So 2 weeks have gone by. There's been a deal for 2 weeks. The seller has essentially taken the house off the market for the last 2 weeks. Seller thinks that we're going forward with the sale of the seller's property. And then lo and behold, 2 weeks into the deal, the buyer decides to cancel and get his money back. Can the buyer do that to the seller? Unfortunately, the answer is yes, due to many buyer contingency rights in the contract. We're going to be talking about those right now. So there's the stage. Let's proceed a little further. I want to talk about old contract law versus new contract law before I mention what the 3 key things are for you to know. Under the older ancient contract law, it was caveat emptor. The seller could keep his or her mouth shut, and unless they affirmatively spoke and defrauded or made intentional misrepresentations about the property, the buyer was stuck with it. There was no exchanges, no guarantees, no refund. So caveat emptor, let the buyer beware, is the old contract law. The new contract law is much different. California, like virtually all states, impose an affirmative duty to disclose, disclose, disclose. The seller cannot just be quiet knowing that the house is about to slide down the hill. If the seller knows that there's a material issue concerning the value or safety of the property, then the seller does need to disclose that. So it's not caveat emptor anymore. The duty of the seller to disclose goes far beyond merely not perpetrating a fraud. Now, when we have an offer on a property in the state of California in residential transactions, it's done with this document, the California Residential Purchase Agreement and Joint Escrow Instructions. That's the CAR Form RPA. That's a California Association of Realtors form, CAR Form RPA. It's this 8-page offer document, very standard. It's used in 98% of the offers for residential real estate in the state of California. The RPA, that's your offer. When it's signed by the buyer and the seller, it becomes the contract. The terms in this 8-page document, unless modified, become the terms of the deal. So the offer, when signed, becomes your contract. So when I refer to the RPA, I'm referring to this 8-page document. A number of contract pages do get attached to it, so the RPA plus any relevant attachments becomes your contract. All right, let's move on a little bit. Without further ado, here are the 3 things you must know about the buyer's right to legally get out of the deal. The first thing you need to know about the buyer's right to legally get out of the deal is that in the typical deal, there are many ways for the buyer to legally get out due to buyer contingency rights. They're called contingency rights, or the right to cancel. Contingency rights with respect to the buyer, that's the right to cancel and get out of the deal. The next thing that you need to know is item number 2. Buyer contingency rights do not expire automatically as time passes. For example, a common time period mentioned in the RPA is 17 days. If the buyer lets that 17 days come and go, the buyer's contingency rights do not automatically expire after the 17 days is gone. They continue. They continue until when? That's the third thing that you must know. The buyer must remove the contingencies or those rights to cancel in writing. And that's pursuant to RPA paragraph 14B and other provisions of the RPA. And the way we do that, it's CAR Form CR, Contingency Removal Form. I'll show that to you in a moment. So, many ways for the buyer to legally get out. I'm going to check through those in a second. The buyer's right to cancel, right to get out, does not expire with the passing of time. The seller or the seller's agent needs to get those released in writing, and the form we use is the Form CR Contingency Removal. Let's move on. I especially want to stop for a moment and drive home this part of the RPA or the contract between the buyer and the seller, and that's paragraph 14B4. It essentially talks about this principle that the buyer has the right to remove the contingencies in writing, and they continue even after the end of the period of time. And here's what 14B4 states. 14B4 is entitled, this section, this subpart is entitled Continuation of Contingency. The continuation of it. The seller wants the contingency ended so we can go forward and close the deal. The cautious buyer will keep these contingencies open as long as possible, as long as we can keep them open in good faith to protect his or her deposit. So we have a back and forth here. The seller is wanting the contingencies removed as soon as possible. The buyer is actually wanting to hold off as long as he or she can do that in good faith. So it reads, even after the end of the time specified in the RPA, 17 days is a frequently referred to time period. and before the seller cancels, if at all, pursuant to 14C, the buyer retains the right, either in writing, to remove the remaining contingencies, which is what the seller wants, of course. We want the buyer to remove the contingencies in writing, or subpart 2, cancel this agreement based on the remaining contingencies. So the right to cancel remains until it's removed in writing. Once the buyer's written removal of all contingencies is delivered to the seller may not cancel this agreement pursuant to 14C1. So 14B4, very important. That's where it states this principle that the buyer has the right to remove in writing, and we simply have to wait for that. And if we do have a cancellation prior to written removal of contingencies, the buyer in almost all circumstances is due his or her deposit back. Let's move a little further. Now, what are these contingencies? What's the legal way to get out? I've listed 13 of them here. This is not an exhaustive list, but these are the most typical contingencies that arise in a real estate transaction where the buyer can lawfully get out of the contract. The primary one is number 1 here, the inspection and right to reject the property condition. After buyers buy properties in California, it's very customary for them to hire a professional property inspector, look over the property, walk around the neighborhood. Even after the deal is made, they can say, well, the inspection report didn't come back right, and even though you may agree to fix these things, I just don't like that property anymore. I'm going to cancel based on my walk around the neighborhood, based on what the property inspection said. So this is a very broad basis for the buyer to get out of the deal. If the property is not insurable, the buyer can cancel. On loans, if the buyer cannot get his or her loan, that can be a basis to cancel. Appraisal, if the property does not appraise at the deal price, the buyer can get out of the contract if that's the way the offer was written and accepted. Disclosures concerning the property, other disclosures, natural hazard disclosure, earthquake zones, proximity to airports, etc. Buyer can get that NHD report and say, gosh, I'm not comfortable anymore, I'm going to cancel. Other inspection reports such as the pest control, termite inspection, septic tank, buyer can decide to cancel based on what those reports say. Even if the seller offers to fix, for example, any termite damage that there might be. Preliminary title report. If the buyer goes through the report and is uncomfortable with some parts of the report, buyer, of course, can cancel. Condominium and plan development. If many homes these days are in a subdivision with HOAs, buyer's entitled to take a look at the HOA documents, and you want to get those to your buyers as soon as possible so you can get those approved and released from the buyer. If the buyer doesn't like the rules in the HOA docs, say the buyer's got 3 dogs. HOA rules only allow two dogs. The buyer is not very likely not going to go forward with the deal because of that. Another thing I want to mention quickly is item number 9, transfer disclosure statement, TDS, from the seller to the buyer. That's required by state law. If the seller knows the house is about to slide down the hill due to various issues with the slope and the geography, the seller's got to disclose that in the TDS and likely elsewhere too. The transfer disclosure document is kind of a super contingency whereby the buyer can actually have released all contingencies. But until such time as the seller delivers the TDS, the buyer's got 3 days to cancel after delivery of the TDS and 5 days to cancel if it's mailed. So sellers, you need to get that TDS to the buyer just as soon as possible to let these time periods run, normally 3 days and 5 days if mailed. Item 10, sex offender database. Buyer can take a look at that database after you have a deal and say, oh, there's a sex offender living 3 miles away, I'm going to cancel. They have the legal right to do that. And here's a couple more. Lead paint disclosure for properties built before 1978. That's a federal law. Item 12, there's sometimes the buyer will say, well, look, I want to sell my property before I buy yours. And if they can cancel if they are not able to sell their other property. And that's RPA paragraph 13, and there's a separate form for this to add to your contract, car form COP, contingency other property. And then finally I'll mention in short sales, lender approval is a contingency. If there's a short sale, you're asking the lender to take a hit on their loan. The deal can't go forward until the lender approves the lesser sum of money and is willing to take the hit. So there's a quick run through of the contingencies. Let's move on a little more here. Here is the car form CR contingency removal form. If you're a seller, you like this form. You actually want your buyer to complete section C right here. Buyer removes any and all buyer contingencies. That's what your goal is. You can remove the contingencies one at a time in section A, the loan contingency, then the appraisal, then the condominium plan development, HOA docs. You can remove them one at a time, that's fine, but you're ultimately going for buyer removing any and all contingencies. And once they do that, assuming you've given them the TDS, buyer's pretty much bound to go forward now, and if they don't, they're going to lose their deposit, at least if you've signed the liquidated damage portion of the RPA. Final form I want to talk about is the car form CC, cancellation of contract. Sellers don't like this. This means that the buyer is in fact going to cancel based on one of the contingency cancellation rights. Very often you're going to use subpart E here as otherwise permitted in paragraph 14 and other clauses of the RPA. Buyer does not have to tell you specifically why they're canceling. As long as they're doing it in good faith, they can just refer to paragraph 14 in general. In most instances, the sellers are well advised to release the deposit A. Seller authorizes the release of buyer's deposit back to the buyer, and as painful as that is, most of the time we're just going to give the buyer their money back and we'll move on as sellers and sell the property to someone else. Yes, it's painful to have had the property off the market for 2 or 3 or 4 weeks or longer, but the buyer has these lawful rights, and once the smoke clears and the seller gets over all his or her anger of going through this, having their property off the market, we simply, in most cases, do end up just giving the buyer their deposit back and moving on and marketing the property to another buyer, and hopefully that one, the deal will close there. Well, there you have it. Hope you found this helpful. Again, I'm Jim Urquhart. This is my son James, is photoed here on the right. If you'd like more information on any of this, go ahead and give us a call at the number here or send us an email. Thank you for watching. Hope you enjoyed this, and see you again soon.